Yeah, and so here again, your friendly local constitutional coop from San Francisco. Now we're going to revisit the issue of evictions and landlords, quote unquote. And what you're going to find here, and I'm surprised at this point, I haven't overtly seen a case like this on the docket with the U.S. Supreme Court this term. But don't be surprised, because this is the next hot button issue. And based on what they've done in recent terms, especially a case called Axon v. FTC, if you read that case and don't know what you're reading, you would think it's landlord tenant. Exactly the same issues in an administrative state where these corporate landlords have complete control of the state legislatures with their political activity committees in Sacramento, where I am, get any law they want enacted on the books and think they can enforce it on you. No, they can't. That's not only not how it works, but they get all this done in a legislature in which the sovereign body politic is not only completely excluded from government, it's systematically prevented from participating in government at any level in any department. Can you say consent of the governed here? Nowhere in sight, just like the right to trial by jury according to the course of the common law, a right secured to at least state citizens, if not inhabitants of territories, since the Magna Carta in 1215, for crying out loud, along with the writ of habeas corpus, that's also vanished into thin air. They don't exist, and the reason for that is the only body politic recognized anywhere in the country today from coast to coast are, in the case of Iowa, Article 2, Section 1, United States citizens who reside in Iowa. Where the hell are the people of Iowa? And that's who they promulgate all the laws in the names of the people of the state of California, or Iowa, just like it is in California. They don't exist. All we have are 14th Amendment citizens. And for those of you that don't know what those really are subordinate corporate entities. That's it, that are subject to the jurisdiction of the United States and can be completely controlled by it. I'm not, you're not. And yet they act like this all the time, even when we bring documents in. And by the way, to learn more about my documents, send me an email, unincourt@gmail.com. And I got a bill of particulars, a motion to dismiss, an assistance to counsel document, and brief on the 14th Amendment, among others, that make it clear that that amendment doesn't exist, and it certainly doesn't apply to the members of the lawful body politic of the nation and republic, or anyone else, I believe, who's not a corporate entity. And that's the battle. And the justices on the court know this. That's what's exciting. First time in almost 100 years, we have an unprecedented window to not only make things better for ourselves, but for our children and our posterity. Exactly as was attempted by the racist framers of the Constitution, in 1787. Now we can do it now. We have that. And that's a lot of bargaining leverage too. And that's another thing, by the way, with these evictions in particular, no statute of limitations on all the deceit, fraud, and treason that went into them. So if you have been evicted, we can get in there and go after them with no statute of limitations and make a serious threat to put them out of business pursuant to at least Section 3 of that 14th Amendment, to which, as we know, Trump isn't subject. An artificial corporate entity is. When they do stuff like that, and they knew or should have known that court never had jurisdiction over you in a landlord-tenant setting, in which the court never had subject matter jurisdiction, not to mention the fact that when you paid the rent, quote unquote, all you did was discharge the obligation in undefined dollars. If defined, they're done by the president acting as commander-in-chief of the armed services, and they circulate in interstate commerce. And the framers knew commerce for exactly what it was: admiralty jurisdiction, the jurisdiction foreign to our Constitution and unacknowledged by our laws, which no state court can exercise. Where the hell have you been in an eviction case? Now, my paperwork says that clearly, plainly, and with attitude and with authority. And the U.S. Supreme Court knows most of it right now. That's what's exciting. And I'm moving as quickly as I can, by the way, on several fronts to let them know that we appreciate what they're doing, but send cases there that they have the duty to hear, not on the appellate side, which is entirely discretionary. And that's what got us into trouble 160 years ago, as William H. McCardle could tell you, when his attorneys filed a habeas corpus under the Habeas Corpus Act of 1867. Now, I can't blame the attorneys then, like I would readily do today for that, because I don't think they knew what was going on. That was a war act of Congress. And it gets there, and the Supreme Court rules against the Reconstruction Act of 1867 and effectively rules the 14th Amendment unconstitutional, but not allowed to announce the opinion because Congress moved the appellate side, which they think they can still do. I disagree with that. Nevertheless, if you and I go to the Supreme Court, and when I go there on my own, I'm going there in the original jurisdiction to which we have a right. And that's exciting stuff that you'll learn. Send me an email, youwinincourt@gmail.com. And among other things from that Cohen's case, and that's the best decision they ever made. And what do they say in there? The court must exercise jurisdiction if it has it, but it can't exercise jurisdiction if it doesn't. The one or the other is treason to the Constitution. That's our salvation. That's how we beat all these backward bastards. And we haul them up there, if need be, on charges of treason. And that's another thing I've been working on creatively here. Is a citizen's arrest affidavit. It's on its way to Merrick Garland right now, the bastard U.S. attorney. Thank God he didn't get appointed to the court. And I'm asking him in no uncertain terms, to arrest a clerk of court and a federal district court for failing to file documents which permitted a court that didn't have jurisdiction to continue to exercise it, and at the same time prevented an Article III federal circuit court from exercising jurisdiction with which it was vested. We should be able to do all of that. And my question to Merrick Garland was, well, what do you think? If I get to the U.S. Supreme Court and it's going to be a one-stop journey, are they prepared at this point in time to order you to do your job? And people, the good news about that is, at long last, with what the court's doing now, we're getting back in a position of rolling the loaded dice, exactly like it should be. And that's good for you, good for your children, good for your posterity. So we see changes like this coming, and have to ask yourself the question, how many of these clerks of court and or Article III district judges, have to end up in jail on death row before they get the idea to do their sworn duty, and rule in favor of the Constitution. It's not hard. It really isn't. I mean, my goodness, they're bound by an oath by this Constitution and laws enacted in pursuance thereof. What the hell is the problem here? So that said, send me an email, youwinincourt@gmail.com. Remember to like the video, subscribe, tell your friends, get the word out. The quicker we act, the quicker this devastation gets over with. And I hope to live long enough to see it here. And I just turned 75. Life is ahead of me. That's how good this is. And that's how good I want it to be for you and your children and your posterity. That you'll be in the same position and have a much freer and fuller life. Thank you.